Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is What's the Word on Wage Fixing? Cracking Down on Collusion Among Employers. Labor market antitrust violations have been a hot topic since at least 2010. In the beginning, there were civil investigations of unlawful agreements among employers in the high-tech and other industries. Then, the DOJ and FTC issued their joint human resources guidelines in 2016. In January 2025, the agencies replaced those guidelines with an even more strongly worded statement about the importance of preserving fair and free labor markets. The antitrust guidelines for business activities affecting workers make it clear that, and I quote, businesses that compete with each other for workers may be committing an antitrust crime if they enter into an agreement not to recruit, solicit, or hire workers or to fix wages or terms of employment. In today's episode, we'll be talking with a former senior DOJ prosecutor about the latest developments on the wage fixing front, including the first criminal conviction for wage fixing won at trial. But first, I'd like to welcome my co-host, Blair Matthews. Hi, Blair.
Hi, Alicia. It's a pleasure to be here today.
Would you like to introduce our guest and kick off the conversation?
Sure, Alicia. We're joined today by Kenneth Dintzer, who is a partner in Crowell Moring's Antitrust Group. He most recently served as Deputy Branch Director in the National Court Section of the Department of Justice's Civil Division, and he is a former senior trial counsel in DOJ's Antitrust Division. He spent 30 years at DOJ, where he handled many varied and complex investigations. We're thrilled to have you here today, Kenneth. Welcome to our podcast.
Thanks so much, Blair and Alicia, and thanks so much for inviting me to join you.
So to kick us off with today's discussion, it would be helpful if you could let our audience know the types of behavior that generally falls within the definition of wage fixing.
Of course. The antitrust laws deal with competition, and businesses can be competitors not only to sell things and to purchase things, but they can be competitors in hiring talented people. When they're on the hiring side, and there's certain conduct that if they engage in would be qualified as wage fixing. And that would be conduct that affects the wages that they pay their employees and others pay theirs. This could be agreeing to cap wages for certain roles. It could be coordinating wage increases or freezes among competitors. And it could be even just sharing compensation data to coordinate or stabilize the pay offered across an industry. And so any of this kind of conduct that has the effect of stabilizing, reducing workers' compensation, that could be wage fixing.
And so something that I think some people might not be aware of is in a typical price fixing cartel situation, the people doing the colluding are horizontal competitors with each other in the same market. The employers in a wage fixing agreement, however, don't necessarily need to all compete in the same market sector or even the same antitrust market as we think of that. Is that correct?
That's correct, Alicia. That they have to compete for the employees. So if you can imagine that in a small town, there's a mechanic who fixes cars and a mechanic who fixes trucks. So they don't actually compete. But in hiring people who can fix cars and trucks, they may be competing for employees. And so they go competitors on the wage.
There could be some legitimate scenarios in which competing employers get information about each other's salary and wage information. I know trade associations collect that kind of data all the time. There might be some types of competitor collaborations, and certainly there are things companies do to find out what, say, the employers who are competing for the same labor are paying. What would be permissible? That is, what are the kinds of things you can do that wouldn't necessarily risk an antitrust violation?
So it's always fair game to go out and try to get public competitive intelligence publicly available, such as wage surveys, job boards, industry reports, and the like. It becomes problematic when employers try to get their hands on non-public information. And let me give you an example from my personal experience. One of the earliest cases I worked on when I was at DOJ involved a set of HR executives in Salt Lake City. And they worked at hospitals and they were hiring nurses, and there was a nursing shortage. And they would get together once a year and exchange forward-looking information about what they were going to do on setting nurse wages. That was problematic because why would you be sitting in a room telling your competitors for these nurses what you were planning on paying? And the department ended up suing both the hospitals that participated as well as the trade organization that these HR executives belonged to. And they all ended up settling and accepting a consent decree. And the court ended up ordering them to stop the communications and to engage in antitrust education.
That's quite helpful. Just going back to situations where the conduct is a little more benign, let's say in the mergers and acquisition context. Now, no antitrust lawyer would ever readily confess to you that they're working on a merger involving two competitors, but in situations where that does occur, would you say that in the due diligence and integration planning phases, there are ways that more sensitive information can be shared about wages or salaries for the benefit of the transaction? And how would you say parties should go about doing that?
Well, the short answer is yes. But the first thing the parties should do is make sure that they really need to exchange the information. The fact that A is merging with B does not necessarily justify people getting into a room and exchanging wage information, but it can, and certainly might be very important. But if they make the decision that it is important, then the second question is how much specificity do they need? Do they actually need to exchange actual wages that they're paying people, or can it be aggregated? Can it be slightly older information as opposed to fresh information? But ultimately, the safest thing that they can do is that they can employ a third party or a neutral who is not involved in the wage setting for either of the companies to be sort of a clean room where they can take in the information and look at it and provide some information to each side as necessary for the transaction, but not actually revealing the deep information that is necessary to set wages.
One scenario that comes up pretty frequently in private practice is a scenario where you could have two parties that are smaller entering a merger, and there's a desire to, for purposes of integration planning, share information about wage and benefit details in order to be ready to compensate employees on day one. For organizations that are smaller like that, where the HR specialty really lies in a specific team of employees and not outside of it, how would you recommend organizations like that go about setting up their clean teams?
I think what you really want is you want some HR professionals on the clean team who are not employees of either A or B, and probably at least one independent lawyer as well. And that clean team then could take in the information and make the evaluations that A and B really need to figure out how much are we going to have to raise B's salary so that they're equal to A's, or what will we have to put on the table to keep this really important employee happy given what their colleagues might be receiving. That information should go through these independent consultants who then can provide insight without providing the information.
Would you say too, Kenneth, that as the parties get closer to closing and closing becomes more certain, that the risk declines?
Yeah, yes, I think that's exactly right. But with the understanding that, I mean, we've all seen deals fall apart, and if the information is exchanged and then the deal falls apart, there's really going to be some risk and some problem there, and potentially a challenge by some of the employees. A and B need to make sure that they're going to go through with the transaction and that there are not going to be any roadblocks before they do sort of the final reveal where they actually tell each other, we are paying Fred $300 a week and we are paying Joe $250 a week. Anything short of that runs the risk that Fred and Joe may somewhere down the line feel that their information has been revealed as a part of a wage fixing scheme and may challenge that.
And now turning from the merger context to agency enforcement, I mentioned in the introduction that there was the issuance by the U.S. Department of Justice Antitrust Division and the Federal Trade Commission of joint guidelines specifically addressing labor market antitrust violations. Those guidelines were notable for their indication that the DOJ was prepared to bring criminal prosecutions under a per se theory against naked wage fixing. And after that, they did. And there were notable cases brought, and we saw that the DOJ had mixed results. Yes, there were some consent decrees, a guilty plea, but there were some losses at trial. However, DOJ finally won one. So, do you think that this trend of criminal prosecution against wage fixing will continue? What do we take away from the mixed results so far? And anything else you want to say about kind of what's been, if not a whole decade's worth of investigatory proceedings, but maybe at least 7 or 8 years?
Sure. While wage fixing has long been a concern of DOJ, its focus on it has certainly ramped up in recent years, with an increased bipartisan attention just on the labor market in general. And one way to track this is to look at the guidance that the DOJ and FTC have provided. In 2016, DOJ and FTC released their antitrust guidance for human resource professionals. It signaled an intent to go after wage fixing and no poach agreements, not for the first time, but a clear intent. In those guidelines, they emphasized that agreements between competitors to limit hiring or fix wages would face aggressive antitrust enforcement. So that's 2016. In 2020, the agencies created guidelines regarding how businesses could share information. By 2024, the information sharing guidance was withdrawn. And in 2025, the FTC and DOJ came forward with new guidelines that further emphasized how serious they were going to take this conduct and bringing forth the intent to go after certain conduct criminally rather than civilly. And so just tracking where the DOJ and FTC were with their guidance, it's clear that they have moved from an intent to go after some conduct to recognizing that some conduct may be worth going after criminally. And it wasn't just in the guidelines. In the no poach context, they went after a number of defendants criminally to try to get a prosecution and were not successful. But they didn't give up. This was something that was a priority. And then this year in US v. Lopez, they found a jury and a set of facts that gave them a victory. Mr. Lopez was a staffing executive at home healthcare agencies in Nevada. And he, according to Department of Justice, he ended up fixing wages at those agencies. And a jury found him guilty of wage fixing as well as a range of fraud charges.
And is there anything in the body of cases and investigations brought so far that might help somebody counseling a business identify the line between what types of conduct might be pursued as civil violations versus criminal violations?
The FTC does not pursue criminal actions. So we're only talking about DOJ. And the things that they'd be looking for are naked agreements, where it's just a straightforward, why don't we all adopt this ceiling? Why don't we all pay this amount? And not tied to some more complicated arrangements and relationships among the different defendants. That's the first thing. The second thing is intent. Wage fixing on the civil side is not really based on intent. It's based on conduct. But if the intent is there, that the parties participating intended to fix wages, intended to create a ceiling, intended to affect competition in wages, then they can pursue and may be able to successfully prosecute on the criminal side.
So, are you able to tell us what in the Lopez case you believe perhaps made that a successful example of criminal prosecution? What were the facts that you think persuaded the jury?
It's always tough to predict why a jury reached the conclusion that it did. The fact that he wore multiple hats with multiple organizations was probably part of it. The fact that they also found him guilty of 5 counts of fraud probably meant that they thought he wasn't a good dude, and that he was probably fixing wages as well. Those probably made these other findings easier to reach.
Another hot topic that we've been looking at in labor antitrust right now are no poach agreements. In your opinion, is there a relationship between what we see in no poach and wage fixing conduct? And in particular, where there is one type of an agreement, let's say a wage fixing agreement, do you also see a no poach agreement going hand in hand there?
So it typically wouldn't be necessary to do both a no poach and wage fixing, since if you're successful in one or the other, they should more or less end up in the same place. Wage fixing is the equivalent of price fixing, but for wages. No poach is the equivalent of market allocation, but instead of allocating a market, for example, let's say you had 2 energy drink companies in the United States, and they agreed not to bring their product into each other's markets. That would be a market allocation. No poach is effectively doing that but allocating labor instead. It's one business saying to another, "We won't go after your people if you don't go after ours." The effect of that can be that employees get paid less because they have fewer options. They can't go to the business across the street and say, "Will you pay me more? I'll come here," because the answer will be no if it's a successful no poach agreement. So they ultimately are different roads to the same place, which is that they can have, if done successfully, a depressing effect on wages and salaries in the relevant market.
It has also been the position of the division to bring claims, both no poach and wage fixing related, though Lopez was specifically wage fixing, under the per se standard. Do you agree that that is the correct approach?
It really depends on the nature of the conduct. If if the conduct is tied up in a complicated franchise agreement or a complicated relationship beyond the alleged no poach and the alleged wage fixing, then per se may not be the right way to go. If you have 2 clear competitors calling each other up and saying, "Why don't we agree not to compete for Fred and Joe's labor? Why don't we agree that you'll keep Fred and we'll keep Joe?" That may be something closer to per se, and something that there's really no need to show the effects, because otherwise they wouldn't be reaching such an agreement. But it really will be very fact specific on whether you can forego the full blown rule of reason analysis, or whether you need to shortcut it with a per se or quick look.
And speaking of how important the factual underpinnings are in these types of cases, another question that comes to mind, are there particular sectors or industries where you think that there's a greater risk of wage fixing conduct? For instance, I know a lot of cases have been in the nursing sector, where there is very high demand with somewhat limited supply. And I'm just curious what your thoughts are on industries where this type of conduct is particularly relevant.
Sure. So there's a few flags that tell us certain industries might be more at risk. One is a relatively small labor pool. If you're looking at a labor pool that involves 40 or 50 employers, any kind of agreement is just typically hard to reach. Moreover, if you have people where the employees are specialized employees, they have special skills, and there's a shortage of people with those skills, that's when you find that employers may be willing to take the risk of reaching out to a competitor and working towards some sort of agreement. So can see that in nursing, of course. We could see that in tech, but it could be something as mundane as a meat processing plant. If you have a time when is a shortage of workers for those plants, and there's only a few of those plants in a town, they may feel like they may benefit if they reach out and contact their competitor. And really, at that point, what HR in each of those meat processing plants needs to do is they need to make sure that they have a protocol for any kind of contact with a competitor about something like wages, and that they have really good antitrust advice before they do any kind of outreach to a competitor, really on any kind of wages or salaries and the like.
So coming back then to one of my early questions about what companies can do to get information, get competitive information about what others are paying, because of course it's extremely useful, every bit as useful as their pricing information, but on the input side. You did mention the use of third parties as intermediaries in the context of due diligence and merger context. We know trade associations collect this information and generate reports for their members with presumably anonymized, aggregated data. But can activities like that, particularly outside the merger context, where a bigger range of data is being collected, let's say the contributors of the data are the ones eagerly awaiting the results, can that process be misused?
Wage or salary surveys based on non-public information, even when created by third parties, are in a gray zone. If they have the effect of reducing competition for workers based on salary, they may cross the line. And so there is some amount of aggregation. If somebody went out and found that how much every gas station worker in the United States was getting paid and aggregated it, that would probably be safe for everybody to buy and use. If there are two gas stations in town and a third party got both of their wage information and aggregated it so that each of them could look at it and say, well, I know what mine are, so now I know what my rivals are, that would probably be a problem. And so it's really important for anyone who wants to buy or take advantage of third party information to know where it came from, to know how it's being put together, and then to have a protocol and maybe a check with an antitrust lawyer to make sure that the information that they're getting is the kind that they can take and rely on without antitrust risk. And the final piece of it is are they being asked to give sensitive information of their own in exchange for it? And that can be where a line exists that they may not want to cross.
As an antitrust counselor, I have gotten questions about whether to answer a survey that perhaps goes into a little bit more detail than is necessary. I am sensing a greater sensitivity to that sort of thing, as the last few years have gone. I mean, wage and salary surveys are very, very common. They are lawful here in the United States, but my sense is companies are being a little bit more careful. Do you have that same feeling?
I do, and I think that's wise. When the information exchange guidelines were withdrawn, they basically at the FTC and DOJ were basically saying to businesses, you're on your own, and the risk is yours if you want to do this. And so, without a safe harbor and without guidelines like that, every business would be better off maybe taking a step back from the line. But if whatever they do, make sure that they have really, really good antitrust advice.
Now, to wrap up this episode, we're going to do a few things we do with every guest, and that includes getting to know them a little bit better as a person and not just as a highly accomplished antitrust practitioner. And the first thing we'd like to do, Ken, is ask you to tell us something interesting or unusual about yourself that is completely outside of your professional life.
So there's a hike in Spain called the Camino de Santiago, which it was always a bucket list for me to walk it. And so this past year in September, I did 30 days of it. I managed to get about 260 miles on the Camino, which is a lovely hike through rural Spain and then stopping at little towns for the night. I still have about 2.5 weeks left, so at some point I have to go back and do those. But that was always something I wanted to do, and it was fabulous.
Well, from my perspective, it beats walking the Appalachian Trail.
That is exactly my thinking, because you get a comfortable bed and a nice glass of wine every single night.
That's wonderful. And now, to round out the show, we'd like to play a little game we call The Curious Hat.
And now it's time for the Curious Hat!
Now, the rules of the game are quite simple. I will ask Blair to pull a random surprise question out of the virtual hat. So take it away, Blair.
We have our question. If you were given $50,000 on the condition that you had to spend it all in 1 hour's time, what would you buy and why?
I would probably, and I don't know how much this costs, but I would probably buy a luxury box at either Nationals Park or for the Capitals. I am a huge sports fan, and the idea of having one of those and then being able to pile all my friends in it every time there was a home game would be really cool. I don't know if $50,000 would get me one of those, but
I suspect not.
maybe just really good seat for one game.
Well, all right. I hope your wish comes true. Thank you so much, Ken Dintzer, and thank you, Blair, and thank you, everyone, for listening. Tune in for next week's Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.